So, similar agenda to our FDCPA case examples, extra credit lecture. Going to give a quick confidentiality disclaimer. Going to break down 3 case studies into 3 levels, the same gold, silver, and bronze, and then review some of the similar strategies and how you can use these case studies in your marketing purposes, for your marketing purposes. Similar disclaimer, we settle a lot of cases. A lot of cases resemble each other. Any similarities to any cases is not intentional or something that may or may not be covered by a confidentiality agreement or just coincidental. Moreover, to the extent that this resembles any real cases, any facts would or may be publicly available. Let's jump right in. This is a technical bronze case under the Fair Credit Reporting Act, the FCRA. Pretty simple. A consumer here filed Chapter 7 bankruptcy and discharged a lot of credit cards. You may remember from an earlier video series, once you do that, you don't have the right or a permissible purpose to continue to access that consumer's credit reports. It's an invasion of privacy. You had a contractual right before while they were, still your client and your consumer, but not anymore. That discharge order signed by a federal judge says that relationship is gone. Notwithstanding here, 2 creditors continued to do so for about 9 months, and we sued. Those settled pretty early, and they weren't difficult cases. Like I said, these bronze cases keep the lights on, but they're, strong. We were very much able to show file bankruptcy on this date, discharge on this date. Here's proof of all of your inquiries. It's not really a difficult case, but still helped this consumer a lot. The creditors deleted the inquiries, that shouldn't have been there. They each paid $2,500 in damages, and then paid fees and costs. So the lesson here is no case is too small, even under the Fair Credit Reporting Act. Think about this. This client had a bunch of debt, went and paid $2,000 and discharged a lot of it, tens of thousands of dollars in this case, actually. But what happened? Months later, walked away with, paid $2,000, discharged a bunch of debts, but now gets $5,000 in damages in his or her pocket. Didn't have to pay for attorney's fees or costs, and his or her credit score went up. So that's a great example of bronze case, the type of thing that can happen under the Fair Credit Reporting Act that may not change lives, but still is awesome. You know how happy that consumer is that filed a bankruptcy and then months later has $5,000 in his or her pocket. It truly makes a difference here. Let's talk about a silver case. This is actually a follow-along case to one of our cases in the FDCPA case examples bonus lecture and extra credit content. You may remember that case. Consumer settled a debt way in the past with Discover, was sued years later. Consumer won. Discover years later turned it over to a debt collector again and sued again. Well, probably not surprising on top of all of that, they were credit reporting a balance still. Consumer disputed many times, 4 separate times in fact, gave all the proof, didn't work. The companies kept, quote, verifying this false debt. So what happened? We sued. The consumer, as you may remember, won both defensive cases, didn't have to pay fees there, walked away with $50,000 in damages under the FDCPA. Well, guess what? Here, there was another $50,000 in damages for the FCRA violations. And then, Discover deleted, the negative trade line. Now, it was too old. It couldn't be there. But let's say, it should have been settled for less than full balance. Creditors will still very often just delete the account as part of a settlement. And here, the lesson is, creditors and third-party collectors, they're lazy, they're dumb, and they're so stubborn, Whether it's profit-driven, motives that make them not hire teams and dispute agents to handle disputes well, or it's just in the face of overwhelming evidence, they just refuse to believe consumers and consumer lawyers. But in this case, a silver status case, incredible result. This client had layered claims, had FDCPA and FCRA claims, walked away with a lot of damages, and really deserved it, Again, the embarrassment of being sued separate times, a public record, maybe being served, the threats of garnishment on a debt you didn't owe. And this is such a fantastic result. And those client outcomes are incredible. The debt's gone, the quote unquote debt, trade lines are gone, credit scores go up, and a huge amount of money in damages. And this case was litigated very hard. So there was a lot of fees paid, and a lot of fees paid to our affiliate partners, as part of our referral programs and our contract programs. Let's talk about a gold case. This is a identity theft type of case with violations due to identity theft fraud. In this particular case, a consumer's Wi-Fi was hacked at a hotel. I'm at a hotel now, but I'm on my secure Verizon pod, so I make sure everything is very secure. But in this case, the consumer just went on the public Wi-Fi and got hacked. It ultimately led to a Wells Fargo account being open, some accounts under checking and savings accounts screwed up. But here, Wells Fargo even sued this consumer later on this debt that he didn't or she didn't owe. So what happened, the consumer goes about a very laborious and arduous process to prove that he or she didn't owe this debt. Got the statements finally from Wells Fargo that were going to a fraudster's address, not his or hers. Was able to prove that he or she was in state X while these charges were happening in state Y. Got an affidavit from a boss. And notwithstanding, no matter how many times the consumer disputed, no matter how many pieces of documented proof were sent along with, it didn't matter. You've probably heard me say, you're going to hear me say, in a lot of ways, these systems are set up to fail, and the disputes just didn't work. And on top of that, not only did they not perform reasonable investigations and kept verifying an amount owed that clearly this consumer didn't owe, they didn't even follow other parts of the statute by blocking the information upon receipt of an FTC identity theft affidavit, or referring notices of an extended fraud alert and dispute to the other bureaus when you get identity theft allegations as part of a dispute. So here, just so many violations on top of each other, just incredible amount of damage here. This consumer lost a job, was being threatened with garnishment, just had a pristine, perfect credit rating otherwise, literally no other negative accounts, and was being denied loans, which only could be traced back to this identity theft issue. So here, the quote-unquote debt was gone, tradeline deleted, credit scores went up, and our client was paid many, many hundreds of thousands of dollars. This is an incredible story because in this case, our client's spouse is able to quit work and then pursue a dream degree that he or she wouldn't be able to otherwise. And all that started with litigation-backed credit repair. This consumer came to us from another attorney just thinking, should I pay this? Should I pay this debt I don't know? Or what do I do? How do I get this off my credit report? So this person was willing to pay $5,000 just to be done with this problem, and instead ended up walking away with life-changing money, increased, credit score, better client outcomes. And the lesson here is, again, litigation-backed credit repair changes lives.